Students, from the last three videos, we are discussing section number 13 of CPC, in which there is a discussion that whether the foreign judgments are conclusive in India or not. Section number 13, in its first part, states that the foreign judgments shall be conclusive in India and these can be enforceable in the Indian courts. But if the case of the parties falls within any exception of section number 13, then it will not be binding, it will not operate as res judicata between the parties. In the present video, I am going to discuss with you clause number E and clause number F of section number 13, in which the foreign judgments shall not be conclusive. Clause number E states that if the foreign judgment had been obtained by making fraud on the court or on the parties, then the foreign judgment shall not be conclusive and it will not operate as res judicata between the parties to the case, because it is the well established principle of private international law that if a foreign judgment is obtained by making fraud, then it will not operate as res judicata between the parties. The Supreme Court of India in Narasimha Rao versus V. Vinikta Lakshmi 1991, 3 Supreme Court cases 451, made it clear that if the foreign judgment is obtained by making fraud on the court, then it will be nullity and it cannot be enforceable in India. In this case, A, who was the husband, obtained a decree of divorce against B, his wife, from an American court on the ground that he was a resident of America. And after getting the decree of divorce from the American court, he remarried with C. B thereafter filed a criminal complaint against A and C for bigamy. A and C filed an application for a discharge in the court that they had not committed the offense of bigamy. Dismissing the application, the Supreme Court of India held that the decree of dissolution of marriage was without jurisdiction and was obtained by making fraud on the American court, because neither the marriage was solemnized in America nor the parties to the case last resided in America. It was therefore not enforceable in India. So this was something about clause number E. Now clause number F states that if the foreign judgment is founded on the breach of Indian law, then it will not be enforceable in India. It has been stated in clause number F that if there is any foreign judgment which comes before an Indian court, that must be in conformity with and must not offend the law in force in India, or it should not be against the public policy of India. But if the foreign judgment offend the law in force in India, or if the judgment is against the public policy of India, then that judgment cannot be enforced in India. Therefore, a foreign judgment for gambling debt which is against the public policy of India cannot be enforceable in India, or a foreign judgment which is based on a claim which is barred under the law of limitation in India, is not conclusive in India because it offended the Limitation Act of India, under which any claim which is barred by the law of limitation in India cannot be enforceable in India. So, in this way, we have studied clause number E and clause number F of section number 13. If you like my videos, then kindly subscribe my channel, and for getting the notes of my videos, you can go to lawarticles2020.blogspot.com. Thank you very much.